Let me begin just by thanking Era, Florence, for having me here, colleagues here in the room, and our good colleagues back in Alicante. I have about 30 minutes or 25 if I rush through my paper. Well, we'll see. I have to rush through anyway because the subject matter is rather complete. And I will deal with certain aspects of infringement litigation concerning essentially European Union trademarks and European Union designs, even though they are still called community designs. And all of this is focused on the territory of the European Union. One could expand on the problems by including third countries, and at the first level, countries bound by the Lugano Convention, where similar rules apply to jurisdiction and enforcement of judgments as they do in the European Union. But I'm limiting myself to European Union, and I'm also limiting myself, maybe with a few references, to registered community trademarks and registered or unregistered community designs. You see that, and the paper is in front of you. You have a copy of this paper, and I've also prepared a number of texts, so you can eventually compare this legislation in these two fields and the horizontally applicable rules. I will describe a few facts which may serve as a point of reference. I highlight the essential issues that I'm focusing on. I'm not going to give you, let's say, the full book on infringement litigation in Europe. There are essentially 5 issues that I'm going to deal with. I will mention the applicable legislation, the competent courts, subject matter jurisdiction, international jurisdiction, territorial scope of competence, sanctions, remedies, applicable law, and a few conclusions. My factual situation is set out here merely to explain to you that we can begin with a very simple case, claimant, plaintiff, and defendant located in the same member state, acts of infringement in the same member state. That doesn't really present the kinds of problems that I'm looking at. But the situation gets more complicated when the plaintiff is in one member state and the defendant is in another member state. And it gets even more complicated when the defendant is not in the European Union, but is in a third country, in this case, in my example, in the United States. And it gets even more complicated when either the claimant or the defendant have establishments or subsidiaries which are located in the European Union or outside of the European Union. And the same thing you can declinate in a way by dividing up different subcases when looking at the defendant. If the defendant is not located in the country where the court is situated, if the defendant is a third country defendant, if there are establishments and subsidiaries, and that is what I'm going to look at. And I'm focusing in this context on what is said on the slide, brings an action for infringement, but I'm mentioning various acts of infringement. Selling, advertising, importing, exporting, infringing products. And you will recognize when you look at these various acts of infringement that they do not necessarily occur in the same member state. You export infringing goods from one member state, even though your production facilities are in a different member state. And the same thing may happen in advertising, spread throughout the European Union, but not necessarily located at the exact location where the party whom you are suing for infringement is situated. What are the 5 issues that I'm going to look at? The first one is obtaining jurisdiction over foreign defendants. That is the general problem that is solved by the regulations on trademarks and designs. A sub-problem of this is when you have multiple defendants in different member states, and even more complicated, multiple defendants of which not all are located in the European Union, but some of them may be located in third countries. You have a particular issue which I call scope of jurisdiction in special situations, And I will come to that in view of some of the cases that have been decided by the Court of Justice. The fourth issue and the fifth issue are interrelated, not totally. We talk about remedies and sanctions. Remedies and sanctions are very important in infringement litigation because just asking for injunctive relief may not really be the final aim. You also want to get recovery of damages. You have the issue of publication of judgments and seizure and claims for information and all of the other elements which belong to the panoply of sanctions that are in principle available once you have a determination of acts of infringement. All of this is somehow related to the issue of applicable law, as should become apparent when I'm going through my situations. You find in the documents that I have given you the applicable legal texts. They are the infringement provisions in Article 9 and 19 of the trademark regulation and the design regulation. They are the applicable rules for civil litigation where the so-called Brussels I regulation is made applicable. Why is it called Brussels I? Because there are other jurisdiction and enforcement of judgment rules which are not covered by Brussels I. Brussels I deals with commercial, civil and commercial matters to which all civil litigation in infringing community rights belong. And we have the Rome II regulation. This is a regulation which deals with private international law, or what some people call conflicts of law situations, when the issue arises, which law do you apply, and in this case to so-called extra-contractual obligations. That's the Rome II regulation. And you find the relevant text, and this is why I've prepared these in your documentation. That's the applicable law. You can distinguish for infringement litigation between what are called European Union or community design courts and trademark courts. There are specific actions which fall into their exclusive subject matter jurisdiction. And then there are other actions which are not covered by the types of actions for which these courts have exclusive jurisdiction. And these belong to the regular national courts, which of course have to apply the regulation, but I'm not really focusing on these other actions. The other actions are actions which are not in the traditional sense infringement litigations. For example, you have a claim, someone owes a trademark to be assigned to you. A claim for transfer of a trademark pursuant to an agreement relates in one way or another to the trademark itself, but it's not covered by these rules for which you have the European Union trademark and design courts. Very simple. In addition, and in a certain degree in the variance to the Brussels I regulation, the provisions in the two regulations tell you in which order you can bring cases against a particular defendant. And you have two types of situations: the EU-wide competence, where you begin with the defendant's domicile or establishment, with the second is the claimant's domicile and establishment. This is I have the reverse order on the screen, but it doesn't really matter, because if you look at this, I just mentioned this because I'm not really dealing with these general determinations of jurisdiction. You also have agreed jurisdiction and you have acceptance of jurisdiction, and you have 2 points to which I will come specifically. What happens in the case of what we call multiple defendants, and what happens in the case when you have territorially limited competence, which is provided for in these respective Article 97, paragraph 4, 5 situations where it is said that you can also bring an action outside of domicile or establishment of claimant or defendant in the member state where acts of infringement have been committed or are threatened. I will point to one of my sub-issues. The first issue that I would like to raise with you, and where I just want to point out that we have a difficulty there, how you define the notion of establishment as used in these provisions of the design and trademark regulation. What is the notion? Is this a notion which you define under the rules of the trademark and design regulation, where the issue of establishment occurs in various situations? For example, the right to be represented by a lawyer or professional representative, as Thomas told you earlier, is no longer necessary for companies or entities that have an establishment in the European Union. Do you interpret these jurisdictional clauses under that particular rule, or do you use instead what is now in the Brussels I regulation, Article 7, number 5? Article 7, number 5 is what used to be Article 5, number 6 in the previous version of the Brussels I regulation, and there it is said that you can bring an action outside of the general rules also in the member state where the defendant operates a branch, agency, or another establishment. That provision has been subject to interpretation by the Court of Justice on various situations, and there is currently a case pending in the Court of Justice which is called Nike or Hummels, depending on how you define it, where the Düsseldorf Oberlandesgericht is asking the Court of Justice whether a second-tier legal entity that is a subsidiary of another legal entity can be considered to be an establishment for the purposes of obtaining jurisdiction over the parent in a broader sense in this sequence of subsidiary and subsidiary of the subsidiary. There's case law in the national courts which have assumed jurisdiction over a foreign defendant on the basis of a local subsidiary, which was an establishment which was separately incorporated as a legal entity. And this happened in the famous Samsung Apple litigation, both in the United Kingdom and in Germany, where the fact that the person on the basis of whom you attach jurisdiction is a separate legal entity did not prevent the court from considering to be an establishment within the meaning of these provisions. So that's one of the issues where we are still waiting for a final conclusion, how you attach jurisdiction over an absent defendant on the basis of an establishment in the court where you want to bring the action. I don't have a final answer for that. Let's wait for how this Hummel case is decided. The second issue which arises is the issue of multiple defendants. The Brussels regulation is innovative, like the original Brussels Convention of 1968 was, in allowing a case to be brought against multiple defendants if one of the defendants is domiciled in the member state where the court is situated, and the other defendant is domiciled in another member state, not in the one where the court is situated, but in another member state. So you have defendant A in member state A and another defendant in member state B, and the Brussels regulation allows you to join these in the same action. That's very innovative because most national procedural rules do not allow you to join multiple defendants merely because you like to sue them in the same court. There must be some relation between them in order to allow this. And certainly not absent defendants, which are normally subject to jurisdiction in a different member country. So Article 88.1 has a long history of litigation in national intellectual property rights, beginning with a case called Roche-Nederland and having been completed by Solvay, but I'm not talking about this. Here we are talking about joining a foreign defendant in the forum state on the basis of his domicile, or we should add establishment, in another member state. The requirement for that is what is called connexity. The requirement is that in order to avoid contradictory judgments, you are allowed to join these two defendants. What are the requirements of connexity? Same factual situation and the same legal situation. All of this has been confirmed in case law in national courts for the infringement of community trademarks at the time, or community designs, where, for example, the defendant is located in Germany, but the maker of the infringement products is located in Spain. And there are various parties in the distribution chain. The German court has confirmed that it has jurisdiction over the Spanish defendant, even though under German civil procedural rules such jurisdiction would not exist. Much of that is undisputed. There's currently 2 cases pending in the Court of Justice, which I've also reproduced in my annex. They are called Nintendo, where Japanese Nintendo is suing a German Big Ben company and joining French mother company of Big Ben. And the question that has arisen, again a reference from the Düsseldorf Higher Regional Court Oberlandesgericht, what is the scope of jurisdiction of the national court over the foreign defendant in this sequence? They have plenary jurisdiction over the German defendant, but do they also have plenary jurisdiction over the French co-defendant, which is joined in this case? This case is currently pending. The written procedure is over. Since we are involved in this, I'm not going to go into the details. So there's the issue of scope of jurisdiction over the joint defendant who is not located in the forum. There's also a subsidiary issue which is not solved yet. Can you use joining a third party when this third party is not EU domiciled or doesn't have an EU establishment? So far, the approach is you cannot unless your national civil procedural rules would allow you to make such a joinder. So that's multiple. I mentioned the establishment issue, the multiple infringers issue, and the application of what is now Article 8, number 1 of the Brussels I regulation. And the third issue is what happens in the case when jurisdiction over an absent, a foreign defendant, is based in the forum state on the basis of acts of infringement which have been threatened or committed. So we are at the obligation to determine what are acts of infringement that have been committed or are threatened. And the basic question there is, on trademark infringement and design infringement, do we talk about a single act of infringement, or do we talk about separate acts of infringement? And what happens if the separate acts of infringement are taking place in different member states? Assume my example, infringing goods are sold in Germany by a foreign company, so you can sue in Germany, certainly for the sale. But can you also sue the same defendant for importing, exporting things which had no relation with the German territory? Very complicated issue of intellectual property law on infringement. Do you really have a single act of infringement which is subdivided into sub-acts? And can you join these infringement acts? That case also currently pending in the Court of Justice in the same Nintendo cases that I was referring to. What are the criteria for determining the member state where acts of infringement have been committed? I have a case which is also reproduced in the annex, which is called Coty, Germany. The Court of Justice was asked by the German Federal Supreme Court to decide whether you can have jurisdiction in Germany over a defendant who is domiciled in Belgium, even though that defendant in Belgium committed sales only in Belgium. The argument for the German court was that they're co-defendants because we call of aiding and abetting. Remember what Annette said earlier, no problem with aiding and abetting. But now we find out there are problems, because if the aiding and abetting takes place in Belgium and not in Germany, the question is, where is the act of infringement committed? In the background, you must know that under the Brussels I regulation, the court has had a very liberal approach for determining the place where a tort, as it is called in Article 7, number 1 nowadays, or quasi-tort or delict, has been committed by giving the claimant the choice between the place where the defendant has acted and the member state where the effects of the damaging act occurred, where the damage actually was occasioned. Annette Cour uses the famous example of the gun you shoot across a border between Germany and France. The act is committed in Germany. The person is damaged in France. Under the case law of the Court of Justice, you have a choice. You can sue either in Germany or in France. Now, the court in Coty said, no, not true for trademarks and designs when they are community rights. Under a theory of avoiding forum shopping, they came to the conclusion that you can only sue in the member state where the defendant acted. If he didn't act there, you cannot get him into the court where you actually want to have him, where the damage occurred. The claim, you cannot define this damage occurring, but you can define where the defendant acted. Good luck for future cases when the defendant is a third country infringer. How do you define where the third country infringer acted? So then it's only perhaps the act of importing. Remember the case of the Rolex watch in Denmark. So my third problem that I want to highlight is that the court's approach to defining the act of infringement by looking at where the defendant acted rather than where the damage actually occurred is limiting jurisdiction in these Article 97, paragraph 5 and Article 84, paragraph 5 cases to situations where you have actually some acts committed in the member state where the court is sitting, not where the effect occurred. And you still have to solve the issue of, do you then have jurisdiction over all acts of infringement or only the particular one in that member state? So that's jurisdiction. My final point in this run-through complications that arise in multi-state infringement litigation deals with sanctions, remedies, and applicable law. Again, we have the trademark regulation and the designs regulation. We have the enforcement directive, which supplements the applicable law, but needed to be transposed into rules of national law. And when you look at what we talk about on sanctions and remedies, we usually begin with injunctive relief and then talk about damages, accounting, information, delivery, and destruction of infringing goods, publication of judgments, cost of litigation. Injunctive relief is actually the easiest because it is provided for in both regulations, and the court in Nokia and other cases has said as a general rule, the infringing act shall be prohibited European Union-wide if the court has EU-wide competence, except in very special situations, which are very limited, totally different from the rule in the United States of America, where the injunction as a remedy needs to be balanced against the equities of the particular situation. So a totally different approach to injunctive relief in Europe. There are some exceptions. A very recent judgment called Combit, decided by the Court of Justice on the 22nd of September, decided that when likelihood of confusion does not occur in all parts of the European Union, the defendant can invoke this as a defense. He is obliged to invoke it and to prove it, and then the injunctive relief will be limited, excluding those territories where no likelihood of confusion occurs. And the court is very specific in requiring the deciding court to delineate these territories very specifically. Again, you find the holdings of this Combit judgment just a month old in the material in the end. So injunctions, while relatively easy, leads us to the next item, which is called damages. Why is damage a sanction? It's a traditional sanction for infringement because the claimant whose rights have been infringed claims that he wants to be put in the same situation he was in before the infringing act occurred, natural restitution or whatever the principle that you apply is. So the first question that we have to ask ourselves, damages, what is their nature? We find a very curious judgment of the Court of Justice, again in my materials, called Gouch. It was a design infringement case, and the court concluded that damages is not a sanction, and therefore the rules which deal with sanctions in case of infringement, which is Article 102 in the community regulation and Article 90-something or 89 in the design regulation, do not apply to damages. And when you tell that to lawyers, damages is not a sanction, So how do we correct this? Is the court in a position to move away from this erroneous perception of what a sanction consists of? That's one thing. The other thing is, how do you measure damages? And here again, and I would call this, the Court of Justice is walking around in a maze. It doesn't find its way in, and it doesn't find its way out, and touches on individual buttons, and everything which comes out of it is wrong. So the Gouch case is the best example. Damages are not subject to the same rule as other sanctions. Now we have a case called Hanson, which involved damages in the case of an infringement of a plant variety protection right, so species which we don't usually deal with. What did the Court of Justice say in the Hanson case? It said the plaintiff is entitled to full recovery of his damages, but he is not entitled to recovery of profits. Recovery of profits that the defendant made as a result of the infringement is not part of the damage calculation. Now that flies into the face of big doctrinal developments in many member countries, including Germany, where the plaintiff has a choice on the calculation of damages by using actual damages suffered, profits made as a result of the infringement by the defendant, or an adequate royalty rate as a third alternative. So finally, we have a situation where the Court of Justice not only says damages are not a remedy for a sanction, but the same court, different composition, says recovery of profits is not part of your damage claim. Now, then you find a very recent judgment called Nikolaeva. It's a reference from an Estonian court, how you determine reasonable compensation for trademark infringement committed between the time of publication and registration. You don't get full recovery, you only get reasonable compensation. So the same court concludes under this reasonable compensation approach, of course you cannot get full damages, but you can get recovery of profits. So suddenly, under the reasonable compensation, the court can say you get full recovery of the profits made by the infringer, but it's not part of the damage calculation. So I'm just pointing these things out because it's an area where you may not logically always look for, but it's part of the confusion which comes out of the Court of Justice, where different chambers deal with different matters and apparently don't listen to each other and write judgments. It's not only that Hauk is basically irreconcilable with matters of trademark principle, but we find the same problem elsewhere. Now, that brings me to my final point, and that has to do applicable law. Why does the issue arise? You would have thought that the applicable law is the law in the regulations, and that's true, but the regulations refer to subject matter that is not specifically provided for as regards sanctions to national law. And you're there at the problem, how do you define the national law that needs to be applied to these situations? The regulations themselves used to say national law including private international law, which is conflicts of law. That has disappeared from the trademark regulation, but is still part of the design regulation. But most people will tell you, of course, the applicable law includes the applicable conflict of law rules, and these are set down in the Rome II regulation. And there is an Article 8 in the Rome II regulation, which deals with extra contractual liability for the infringement of intellectual property rights which are protected European Union-wide. There's an 8.2, which says essentially, the applicable law shall be determined by the law of the country where acts of infringement have been committed or are threatened. So we are back to the same problem that we had to solve in the context of jurisdiction, now in the same context of applicable law. And here again, the two companion cases called Nintendo, Big Ben, present the issue of how you determine the location where acts of infringement are committed, not for jurisdictional purposes, but for applicable law purposes. The Court of Justice has been reluctant to introduce the conflict of law rules into its jurisdictional rules because they say they follow different rules and principles. But it will be interesting to see how that issue is resolved. So that brings me to my end. These 5 issues that I've raised, jurisdiction over foreign defendants, multiple defendants, acts of infringement, sanctions, in particular the issue of damages, and the applicable law will be with us for a long time to come. And I recommend these cases as they're coming out of the Court of Justice for your attention. I know it's late in the day, but I hope I've stayed more or less within the time that I had. And I do thank you very much for your attention. Thank you.